In this video, we'll be covering the concept of office of profit, its origin, and its significance. Means why do we have such a term of office of profit? Now let us go to its origin. Its origin is there in 1701 Act, that is Act of Settlement in Britain, which laid down this principle of office of profit. It basically entailed that any person who holds any office of profit under the king, means if he is employed by the king or receives pension from the crown, shall be not be capable of serving as member of House of Commons. The idea behind this was that if he is employed by king or he is under patronage of king, he may not be able to discharge his functions in a fair and an impartial manner without being influenced by the preferences of the king. So the idea was to strengthen the democracy and to ensure that those who are public representatives, they are able to freely participate in the discussions in the parliament or in the house. Now let us have a look at what principle do we have in US. In US, if a member of Congress wants to join the executive, there are certain restrictions. He cannot be part of the executive for a particular post if that post was created during the member's term in the Congress, or if the compensation or the remuneration which is payable for that executive office was enhanced during the member's term of office. So you can clearly see that the real intent here was that a member is not given any kind of inducement by the executives, means being a part of Congress, he should not be induced to join the executive where he has given some kind of favors in terms of voting, in terms of preferences towards a particular executive office. And as a corollary, a executive cannot become member of the Congress. Like as a member of Congress cannot join the executive office under two conditions, and on the as a corollary, a an executive cannot become member of the Congress. Now as I have mentioned, that the principle behind this restriction of not having such kind of an office where you're likely to get some kind of inducement or some kind of favors is to avoid the conflict of interest and insulate the public representatives from the executive patronage. Now, what can be the office of profit? How do you define, how do you say that a given office is indeed an office of profit? Actually, this has not been defined either in the Constitution of India or in the Representation of People Act. Constitution of India and Representation of People Act, they both make a mention of the office of profit, but do not define it in so many words. So then it is left to the courts and also to the adjudicating bodies like Election Commission to decide whether a given office will fall in the category of the office of profit. Now, for any office to become an office of profit, one has the person who is occupying the post or that office of profit should be capable of getting financial advantage or benefit. He may not be getting or taking any advantage, but merely if he is capable of getting it, then he or she may invite the interpretation that the office occupied by him or her happens to be office of profit. And amount of profit or the amount of remuneration, you may say that this office gave a very little amount, but that hardly makes any difference. As I said, if the office is capable of giving you the advantage or the benefit, then it may come. I'm not saying it shall come, because it is for the court to look into the matter. It is for the adjudicating bodies to look into the matter. They will go into the facts and circumstances of the case. Each case has to be decided on merit, and they will finally give their judgment whether this office is or is not an office of profit. Now, when we'll proceed further, we will see that in the Constitution and also in the Representation of People Act, there is a clear bar on the members of Parliament and also the members of the legislative assemblies and the legislative councils, that is the state legislature, MP of Lok Sabha and MP of Rajya Sabha. They cannot hold an office of profit. The only office which they can hold is the office of minister and such other office which is not declared as office of profit. Now, there is an act, a union act, a central act, which is called Parliament Prevention of Disqualification Act 1959, which basically lists down certain offices which are not to be considered as office of profit. So if a person who is an MP happens to hold that office which is mentioned in section 3 of that act, then that person may not invite or shall not invite the disqualification, because it has been categorically laid down in the act itself that such and such office is not an office of profit. If you recall, during UPA time, the National Advisory Council post, that is the chairman of National Advisory Council, was being argued by the opposition at that point of time that that post happens to be an office of profit. So the person who is holding that post as a chairman of National Advisory Council at that point of time should have been disqualified, because the Constitution and the Representation of People Act both bar a person who is an MP to hold an office of profit. But subsequently, by an amendment, that post of chairman of National Advisory Council was also added in this act. So by inclusion of that post in that act, the debarment process cannot start, because it has been declared that such and such office doesn't happen to be an office of profit. So there is a lot of debate on that, whether such inclusion should be allowed, but that is the domain of the Parliament. The Parliament can make legislation, and under that legislation they have identified certain offices, and they can amend that legislation amend that act from time to time by adding more offices to it. Now, moving forward, let us have a look at the provisions in the Constitution of India which make a mention of the office of profit. Now, Article 18, if you remember, Article 18 is part of the fundamental rights, and Article 18 basically debars that no citizen of India can take any title other than academic and military. Now, it also says a person who is not a citizen of India, means the citizen of India are completely barred to take titles from a foreign country also. So, but a person who is not a citizen of India but happens to hold an office of profit. Now here again, in this chapter of the fundamental rights, the office of profit has not been defined, but it only says if the person who is not a citizen of India but happens to hold an office of profit shall not, without the consent of President, receive any foreign title. And it also says, even if a person is not any person, citizen or non-citizen, cannot, without the consent of President, take any profit, any kind of emolument or any gift from any foreign state if that person happens to hold an office of profit. So it again, basically the intention here is that a person is not influenced by the foreign powers while he's holding an office of profit in this country. Now, if we move forward, then if we go to the qualifications of the president, Article 58 clearly says that a person who is holding an office of profit or who holds an office of profit, either under government of India or government of any state, or in fact, this is very interesting, even under any local body or any authority under control of government of India or the state government, if he's holding any office of profit, it doesn't say if he's holding any office. It says if he's holding any office of profit under these governments, that is state government, government of India, any authority, any body under the control of government of India or the state government, then that person shall not be eligible to contest for the election of the president. And further, Article 59 says that this is part of the conditions of office, that a person who is President of India shall not hold any other office of profit. So he is holding office of president, but he cannot hold any other office of president. That is while continuing in the post of President of India. Here a clear explanation has been given that certain offices which are declared not to be the office of profit, which will not deem to be, not declared to be will be the wrong word to use. In fact, the Constitution, the article explanation clearly says that the office of president, office of vice president, governor of any state, a minister of union or of the state, that shall not be deemed to be the office of profit. Now, coming to the qualification of vice president, same thing is mentioned as for the office of president, that for a person to contest for the election of vice president, he should not be holding any office of profit under state government, union government, or any body or authority under control of these governments. And the explanation again says that the president, vice president, governor of the state, minister of union or state are not considered to be the office of profit. Now, these are the important articles of the Constitution on which whole debate and the controversy emerges. Article 102 basically lays down when a person can be disqualified from being the member of the parliament. It says that besides, amongst other conditions which are there, we are not going into that because we are confining our discussion to office of profit. It says that if a person holds any office of profit under government of India or government of any state, and read that line carefully, other than an office declared by parliament by law not to disqualify its holder. So other than those offices which have been already declared by parliament by law, as I initially mentioned, under that law the offices are declared which are not the office of profit. Other than those offices, if a person happens to hold any office of profit, then and he is member of parliament, then he is subject to disqualification. Interesting thing we have to see here is that in case of president and vice president, the office of profit could be under government of India, government of state, and also the local authorities. But in case of member of parliament, the office of profit is only under these two bodies which is barred, that is the government of India or government of state. So that's a major difference between the restriction on the office of profit as regards the president and the MP. The spectrum is much wider in case of president as compared to that in case of member of parliament. Now, similar provision is there for the state legislature. Like for the parliament, it was 102 article. For the legislature of state, exactly similarly worded provision. The only difference is that if you go back in case of parliament, it is the office which could be declared by parliament to be an office of profit. But in case of the state government, it is the legislature of state which can make law to declare that certain office is not an office of profit. Now, coming to the difference which I have already covered, that in case of president, the person cannot be holding office of profit not only under the government of India and government of state, but also under any other authority or any local body under the control of state government or union government. But this is not the case in case of the member of parliament and also in case of the state assembly. Now, how the disqualification happens? Suppose a person is holding an office of profit or is a subject to disqualification because of the other provisions of section article 102 and article 191. And now let us come only to the office of profit condition. Suppose a person attracts this condition that there is an allegation, there is a claim that he is holding an office of profit. So when such a question has been raised, then how the system works, how it happens that a person is finally declared to be disqualified. If a question is raised, it is referred to the president or the governor. President in case of MP and governor in case of the state legislature, MLA or MLC. And in fact, in the constitution itself, it is provided that a president shall, or the governor, as the case may be, in different articles it is mentioned, shall refer it to the election commission, obtain its advice, and election commission goes into the merit, like it happened recently in case of the MLAs of the National Capital Territory of Delhi. Commission gives it advice, and one thing you may please note that it is binding. This advice is effectively binding on the president and the governor. It says, the article of the constitution says that the president, or where it is mentioned the governor shall act according to such opinion. That is it is not the word of advice, it is the opinion given by the election commission that such and such person who is holding the post of who is MP or MLA happens to hold the office of profit, and therefore he is subject of the disqualification. Now, coming to the other constitutional functionaries where such condition is put, in case of governor also it is mentioned that he shall not hold any other office of profit. You can clearly see that other word is clearly mentioned. So he can be the governor, he is the governor in fact, but any other office of profit he cannot hold. Unlike the case of president and vice president, where explanation was given that the post of president, vice president, ministers of state and union and governor do not constitute office of profit. Any such explanation is not given in connection with the article which pertains to governor. So we'll go by the explanations given earlier in the other articles. Now, coming to the law in India, I had already mentioned that Representation of People Act clearly bars that MLAs and MP cannot hold any office of profit, and it is in harmony with the provisions of the Constitution, that is Article 102 and 191, which also say that they cannot hold any office of profit under union and the state government. Now, I was mentioning about this Act of Parliament which lays down the offices which do not attract the disqualification as being office of profit for an MP, Section 3 of this act, in fact this act is made as per the provisions in the constitution itself, which we mentioned, which we saw in the article 102. So this is an act of the union government in accordance with that provision of the article of the constitution, and under section 3 you can see there are offices which have been declared as not to be the office of profit, and you can see that in May 2004 the office of chairperson of National Advisory Council was also added as the office not to be considered as the office of profit. In fact, certain other offices were also earlier added. You can see that if you recall, under the Constitution of India, under the original provision of Article 338, there was only one national commission which was for both the scheduled caste and the scheduled tribe. This was later on amended and separate article was inserted, 338A, for having a commission for the scheduled tribe, and 338 then only covered the commission for the scheduled caste. The original act of the parliament covered only 338 article, but because separate commission was made for the scheduled tribe, this also had to be added. So this was accordingly added by an amendment that this is not an office of profit. Now similar provision is there in case of the state government. As we saw under Article 191 that states were empowered to declare certain offices not to be deemed to be office of profit, like Parliament has done. Various state governments have their own laws and they have declared. This I am showing is the act of Meghalaya government, which says that following offices are not the office of profit. And interestingly, if you see, Meghalaya had declared that the office of parliamentary secretary to the government of Meghalaya shall not fall under the category of office of profit. But here in case of National Capital Territory of Delhi, we are seeing that those MLAs who are holding the post of the parliamentary secretaries, they have been recommended for disqualification. Reason being that there is no such provision in the act for the National Capital Territory of Delhi, because that post has not been excluded from the disqualification for attracting disqualification as office of profit. So in the other states this has been done. This is for Pondicherry. You can see there are various offices they have done, and for Delhi also we have an act, but as I said, the parliamentary secretaries is not mentioned there. So that's the proposition as it stands today. These are the certain instances where the issue of office of profit was raised. Mrs. Sonia Gandhi had to resign from certain other posts. She continued to hold National Advisory Council chairperson because that office was excluded from the office of profit list by the act which I have just shown to you. The other instance is of Miss Jaya Bachchan, who was disqualified from being member of Rajya Sabha because she was holding the post of chairperson of UP Film Development Federation. Similar thing happened in case of two UP MLAs who were actually not holding the office as such, but they were having interest in the government contracts. They were direct party to the contracts. They were participating in the contracts, or they were partners in the contracts with the firms who are having contracts with the government. So you can see there is a clear case of conflict of interest. These MLAs could be influenced by the executive, so definitely there will be a conflict of interest. So that office was taken as an office of profit. And the recent case of January 19, 2018, where 20 AAP MLAs have been recommended by Election Commission, or in its opinion it has said that they are holding the office of profit. Now, in Jaya Bachchan's case, the Election Commission has made a very interesting observation. It says that Any post, even if held in an advisory capacity, was an office of profit. Means the basic fundamental principle, as I said earlier, is that if the post is capable of giving you benefit or profit, or the post which you hold gives you some kind of assurance and your independence as MP or MLA is likely to be compromised, then that post can fall in the category of office of profit. In UPMLA case, I mentioned that they were having interests in the crores of tenders which were being given by PWD. In fact, they were sole proprietorship firm of these people. So it was found in the Lokayukt probe. Finally, they were declared to be holding the office of profit and disqualified. Now, as we see in the debates, there is no clear-cut guideline so far, no clear-cut laws saying that such and such criteria has to be followed for declaring certain office as an office of profit. You have a law which says that following offices are not office of profit. Of course, you cannot have a law which lists down all the offices as office of profit, because it's a dynamic process. A new office may get created. So what you need is not a list which says that following offices are office of profit. To attend to the difficulty of the debate which we face, whether such and such office happens to be office of profit or not, is that we lay down a more comprehensive and a clear guideline that these are the parameters which will decide that this is an office of profit. Of course, there will always remain gaps and there will always remain the subjectivity in the decision making, but to the extent we can make it objective by having a more detailed guideline, it would be setting aside the controversies and the debates on the office of profit. Supreme Court has tried to address this time to time in various judgments. It has laid down various tests, and one of the important tests is the test of appointment. Means, who is the appointing authority? This is the case. This is a constitutional bench in Gobind Basu versus Shankari Prasad, and in this case, Supreme Court had laid down certain guidelines that who is the appointing authority, and who is the authority which is vested with the power to terminate. Who is the authority which determines? Which is the authority which determines the remuneration, the source from where the remuneration is paid, and the authority which controls the manner in which the duties are to be performed in the given office of profit. So if you can see, the entire spirit of these observations is that whether is it the government which is able to influence that person by being in that office by various methods of appointment, by remuneration, by controlling the conditions of office, and also by termination. So if these are there, then it's very likely that it may be declared to be an office of profit, though you may not be taking any profit out of it, but you are capable of being influenced. So let us take another case. This happened way back, where Ramakrishna Hegde, if you remember, a very prominent politician who happened to be the member of the Karnataka Assembly, was appointed as Deputy Chairman of Planning Commission. Now, this matter also attracted an issue whether he is holding an office of profit, that is the office of Deputy Chairman of Planning Commission. Will that be an office of profit? And if that is an office of profit, he has to be disqualified from being the member of the assembly. So in this case, the court has held that it is not an instance of office of profit, And court in fact has to see various aspects. Again, it will depend on the merits of each case, and you may find certain conflicting observations which may appear conflicting to us, but then it is for the judiciary to take a final call on that, and we are not there to make any judgmental observations on that. But this is where the case of Ramakrishna Hegde stands. Now, let us look at the case of this former Prime Minister P.V. Narasimha Rao. In his case, under Prevention of Corruption Act, as you know, there was a criminal charge sheet against him after he had left the office of Prime Minister. And in that case, an interpretation was made that the office of MLA holds an office. So, under PC Act, the public office, a person who holds the public office, it was declared that MP, MLA also holds a public office. But whether that office is an office of profit, no. The office of MLA, it is an office, because that interpretation has been given. If a person is an MLA, he holds an office, but that office is not an office of profit. So these are certain other cases you can just go through which had attracted debate and controversy regarding office of profit. There is a joint committee of parliament having 10 members of Lok Sabha and 5 members of Raj Sabha, which from time to time scrutinizes the offices which ought to be declared as office of profit, or which are to be declared as not being the office of profit. And the tests which are applied by this committee are the emoluments and the allowances attached to the members, and nature and function of the body. Now, these are some other cases where in one case, High Court of Rajasthan had said that the office of Oath Commissioner happens to be an office of profit, because the Oath Commissioner is appointed by the government and the office brings a profit to the holder. So this is an office of profit. In fact, if an office is under direct control of the government, or the government is paying remuneration to it, then it certainly very clearly becomes an office of profit. There is hardly any room left for any other interpretation. Now, this is another test, though we have mentioned in the previous slides where Supreme Court had laid down the test of appointment. It is again on the similar lines. It says that the first question to be asked is whether government has powers to appoint and to remove from an office. If the answer is negative, then the matter ends. It is not an office of profit. No further inquiry is required. But if government has powers to appoint and to terminate or remove the person from that office, then certainly there are doubts to be raised and the further inquiry has to be made, probe has to be weighed. If the answer is positive to the above question, further probe has to be done. Whether on account of holding such office would the government, this is important, very, very important. In fact, this clarifies a lot of doubts. So if the government is appointing and government is removing, and in that office government would be in a position to influence him or her as to interfere with independence in functioning as an MLA and MP, then certainly that office happens to be the office of profit. So if it compromises the independence, if a person who holds that office which has been given to him by the government and government is in a position to influence him, to compromise his position as MP and MLA, to compromise his position to independently function as an MP and MLA without being influenced by any factors, then certainly that office can come as the office of profit. Now, there are certain good practices. In England, the origin lies in the England, and also the good practice is also derived from there. Interestingly, whenever a new office is created in England, and if a government creates any new office, it very clearly says whether that office will be considered as office of profit or not. We can also follow that. We can have an elaborate law laying down the guidelines and parameters, and we can have various mechanisms of annual review. We should have such sturdy and such formidable mechanisms which leave no room for any doubt or any controversy that there has been any unfair finding of any body or authority in declaring a particular office as an office of profit. It should be guided not by the person or the party or the person representing any party which is holding that office, but the parameters should be so clear and crystal clear and lucid that merely by application of those parameters you come to a conclusion that this office is an office of profit. Of course, with all those things, still there would be doubts, but we have to minimize the areas where one can raise questions. So these are the broad issues which I think we need to look at the office of profit. Thank you.